Hey there, guys, and welcome to the first of a two-part series on police powers. Now, the reason I've split this up into two parts is because it's such a wide-ranging topic, even though we are only going to be focusing on one particular statute, the Police and Criminal Evidence Act 1984. Now, the police are unusual in the sense that they have powers that range way beyond those of the ordinary citizen when we think of them arresting and questioning suspects. But we do also have to bear in mind that in the interests of justice, there are limits on those powers. One of the first cases that you cover in police powers is normally Rice and Connolly, where the police stop someone and ask them questions and the person refuses to answer, and the citizen is well within their rights to do so. Now, it's important that there is the correct balance between allowing the police to do their job and the individual rights of the citizen, and we'll see throughout this lecture how those have been impinged as time has progressed. So in the recent case of Begale and DPP from 2015, there was a case there where under anti-terrorism legislation, a suspect was forced to answer questions in response to police questioning. This obviously goes against the principle of Rice and Connolly, but is also seen as a response to the threat of recent terrorist attacks. So in the first part, we're going to look at all of the police powers up until arresting someone, and then in the second part, we're going to look at things like arresting someone, detention, and also questioning as well. Right, let's get started. As I mentioned in the introduction, the main piece of legislation that we're going to be looking at is the Police and Criminal Evidence Act 1984, or PACE as it's more commonly known. It may be useful before we start to give a little bit of background to this act. And so in 1981, the Afro-Caribbean community of Brixton began to riot because of heavy-handed police tactics. A response to the riot was brought about through the Scarman Report, and this suggested that police tactics should be a lot more heavily regulated, and so this eventually gave us the PACE Act that we still use today. Now, alongside the PACE Act 1984, in a bid to keep this constantly relevant, are also the codes of practice that are used still today by the police. As I say, these are updated regularly, and I believe that the latest update was from 2014 from the Home Office. And so these are, in combination with PACE, are worth keeping at the back of your mind when answering any question on police powers. This is the key statute for you to use. So the first section of PACE looks at stop and search, and this is probably one of the most controversial areas of police powers in recent years because of allegations that police are using stop and search in a racist fashion. Now, in order for a stop and search to be carried out by a police officer, there must be reasonable suspicion, and the idea of reasonable suspicion is in bold because it's an idea that we'll come back to on the next slide. But a reasonable suspicion that the person is carrying either stolen items, offensive weapons, items used for the crimes that are listed there, or also fireworks as well. Now, let's go back to reasonable suspicion. Now, certain things, including reasonable suspicion that would be sufficient grounds, tend to be linked towards police intelligence that is currently factually accurate. So if a person matches a description of a suspect, then that could be reasonable grounds. Intelligence linking a person to offences could also be sufficient grounds, and also suspicious behaviour. So if a person is acting a little bit out of character or seems to be acting strangely, then that might be sufficient grounds to establish that reasonable suspicion that's important. But the key focus here is that it has to be linked to current police intelligence rather than any stereotypes or alternatives. So if we look at the insufficient grounds, we can see things like race, religion and appearance cannot be considered to be sufficient grounds. So simply stopping and searching someone because they're black or because they're a Catholic will never be sufficient. It's also important to note that previous convictions will not count either. And so this is something where students tend to get a little bit confused on because they think, oh, well, that person's committed a crime in the past, therefore it's reasonable to suspect them of committing a crime again. But this goes against the ideas of criminal justice, whereby if someone has been convicted in the past and they've done their time, then it's unfair to hold that against them in the future. And so to simply suspect them because you know that they have a criminal record cannot be considered sufficient grounds. It links back to the idea that it has to be current police intelligence rather than past previous intelligence, as would be the case with old convictions. So stop and search is designed to take place in public, just on the street. And so with this in mind, you obviously can't do a complete strip search of someone when you're out on the high street. And so only outer clothing can be removed. So things like gloves, hats, coats, that sort of thing. But anything more intimate than that is not appropriate to do a stop and search on the police of that. If the police did decide that they needed to do a more intimate search, then they could do that back at the police station, as long as they did have that reasonable suspicion that a person was concealing, for example, a weapon underneath their clothes. You may also have noticed that I've not actually talked about drugs so far as part of this. We've mainly talked about stolen goods. If a person is suspected of carrying drugs on their person, that's obviously still relevant for stop and search, but the stop and search powers come under the Misuse of Drugs Act 1971 rather than PACE. Now, when the officer does decide to stop and search someone, there's a certain amount of information that must be given. The officer's name and their station, the object of the search, in other words, what the police hope to find, whether that's an offensive weapon, etc., and the grounds for the search. In other words, why is this particular person being searched rather than somebody else? Now, moving on to searching premises or property, this is a very controversial idea and stems back to the case of Entick and Carrington 1765, where the courts really established that a person's home is their castle and that the authorities of the law shouldn't be allowed to just wander straight in. Now, obviously, that's an important principle and is also linked to the more modern concept of Article 8 of the European Convention on Human Rights. But in order for the police to also be an effective crime-stopping force, they do occasionally have to enter premises. Now, this can be either with a warrant or without a warrant. And so, first of all, let's have a look at the circumstances under Section 8, where a justice of the peace or a magistrate can issue a warrant to the police to search a property. So firstly, there has to be an indictable offence that's been committed, in other words, something that can be charged within the Crown Court. Secondly, there also has to be material on the premises of substantial value to the investigation. Thirdly, and this links to the second point, it has to also be considered to be likely to be relevant evidence as well. And also the material has to be really standard things that you would find in evidence, not things that could be subject to legal privilege or excluded material, evidence in other words that couldn't be admitted, or special procedure material as well. So that's searching with a warrant. The police can also, under certain circumstances, take a search without a warrant. Under Section 17, this can be to place a person under arrest. So if a person does run back into their home when the police are trying to arrest them, the police are entitled to follow that person into their home in order to effect the arrest. Under Section 18, this is also linked to search premises that are occupied and controlled by a person under arrest. And then under Section 32, to search premises where a person was immediately prior to their arrest. So say if a person was running through a building site and then they were arrested, the idea being that they might have dropped off particular stolen goods or hidden them to find later on. And so it's important that the police are allowed to search those premises in case the suspect has tried to get rid of evidence. Now, also indirectly linked to searching premises is the idea of bugging a place of work or a home as part of an investigation. And this links back ultimately to the case of Malone in UK 1984, where the police had been bugging a particular person's house and tapping their phone line for a particular period. Malone complained under Article 8 of the European Convention, and the court said that the UK did not have a sufficient statutory regime to regulate the bugging of people's homes or places of work, etc. Now, this ultimately did not come under PACE, but did come under the Police Act 1997, and so the UK did respond. In other words, they were saying that it's okay that the police do have the power to bug people's homes or places of work, but they have to have a particular statutory regime in order to do so. However, there aren't too many limits on where the police can bug people, and so that's a little bit controversial. Even things like solicitors' offices can be bugged. Also, doctors' surgeries can be bugged. Even a Catholic confessional booth can be bugged as well. Finally, in terms of seizing property that the police find, under Section 19, they can seize anything if they believe it was obtained during the commission of an offence, or if it is evidence in relation to any offence, or it is necessary to seize the property in case it is lost, altered, destroyed, anything like that. Now, in relation to that second point, evidence in relation to any offence, this is really important. So it just doesn't have to be just the crime that the person is suspected of. It can be linked to other crimes as well. So this gives the police the power, in case they do find something that is suspicious or links back to another crime, which they may not even suspect the person of, that they do have the power to remove that so that the evidence doesn't later become destroyed or altered at a later date. In the case of Jeffrey in Black 1978, the person was under suspicion of stealing a sandwich from a pub. The police followed him back to his home, and when they searched his home, they found that there was cannabis there as well. Now, obviously, this wasn't in any way linked to the stolen sandwich, but obviously possession of drugs is an offence as well, and so the person could be convicted even though the search didn't take place for that particular purpose. Thanks very much for watching. If you did find this useful, then also remember to check out the second part of the police powers videos. Also, I really appreciate it if you do take the time to do the whole like, comment, subscribe thing. Thanks again. Bye.